So the agent has to disclose any material facts about the property that they're aware of. So the seller should have told the agent, but if the agent didn't know, the agent can't be obligated to disclose. So ideally, your realtor representing you as the buyer would have put in a clause about things like flooding or recurrent issues to draw out, is the seller aware of, or the seller represents and warrants that there has never been any kind of, I mean, you would almost have to be aware prior to the offer that there was flooding to have the foresight to put in a clause that says there never was flooding. So it's tricky. You're really relying on the seller to disclose it. If you can prove that the seller experienced flooding every year and didn't relay that information to you, you may have a case there. The seller could argue that any time it flooded, they remedied the flood to what they thought was its fullest extent and maintained the property and restored it. If the seller truly believes that the property flooded, they fixed the issue, they restored the space, and now there's no longer an issue, they have nothing to disclose. So it becomes this sort of murky fact-finding mission on your part where you're trying to prove that they were aware that there was an issue, and they're gonna have to prove that they were also aware and that they didn't do anything to remedy it and that they withheld that information. It's tricky, but I understand the frustration and I would probably go down that road as far as I could, but ultimately I would just work to restore my own property as quickly as I can, and hopefully the damage isn't too bad. If it gets to be an incredible amount of damage that is obviously the result of sustained negligence on the part of the seller, then I would probably speak to a lawyer and see what my options are. So the recourse would be, you could find the recourse or your avenues for recourse in your agreement of purchase and sale. So there would probably be a clause in there that chattels and fixtures will be in good working order. That would include the oil tank, but it really only goes up until closing. And then on the day of closing, when title transfers, it's now your responsibility to maintain that oil tank. When in the question it says supposedly there was an inspection, that makes me wonder, did you as the buyer have your own inspection done? If you didn't, the onus would be on you and on your realtor to make you aware that you have the right to have an inspection. So you could have had someone in to sort of look at all of these things and then raise any flags at that point. And then a negotiation ensues where you can say, before I remove my inspection condition, I'm going to ask that you replace the oil tank. That was an opportunity that you had prior to the close. Once the property's closed and title has transferred, it's far more difficult for you to go back and renegotiate these things, especially if your agreement of purchase and sale didn't protect you the way that it could have.